morning, everyone. Before we begin, are there any special requests from the state, Mr. Reichenberg?
No, Your Honor, thank you.
Any special requests from defense?
No, Your Honor.
Then I will call them in the order they appear on my calendar. Let's start first with Adriana Garcia.
Here's the microphone.
Okay. Good morning, Ms. Garcia. It looks like you did not fill out an application for the public defender's office. Would you like to do so at this time?
Yes.
Yeah.
Yeah. Yes, please.
I heard yes.
Yeah, please.
You receive any government assistance, ma'am?
No.
Food stamps, Medicaid?
No.
What is your weekly household income?
It just depends because I do some construction work. I'm not exactly sure.
Do you have any income while you are at the Washoe County Detention Facility?
No.
And the total number of people that reside in your household?
4?
Do you own a home?
No.
Do you own a car?
No.
Do you have any stocks, bonds, or investment accounts?
No, I do not.
Court will find at this time that she is presumptively eligible for the public defender's office and duly appoint them to represent her in this action at this time. What's the state's position regarding her custody status, Mr. Reichenberg?
Yes, Your Honor. We're asking for $20,000 bondable bail on Miss Garcia, DAS supervision, and no driving unless licensed. She doesn't have a lot of criminal history. However, I think concerningly, she has a failure to appear on a driving without a license in Reno Municipal Court. And again, as noted in the probable cause sheet, this was the second time she ran from law enforcement, and it ended in a crash, which was extremely concerning for the risk to the public. And so based upon that, we believe that bail and supervision is appropriate.
Can I say something?
Well, here, I'll see.
Well,
Hold on. What? Usually I would go.
okay, sorry.
Anything further from the state?
No, Your Honor, thank you.
And it's Mr. Watson.
Yes, Your Honor. So we'd be asking for an OR release today. As the state pointed out, she doesn't really have a criminal history. She has maybe one prior charge. I understand the state's concern. I think there are some conditions that can be fashioned to ensure safety of the community. One of those would be a no driving clause. It seems like she doesn't own a car anyways, so I don't think that would be a problem since it seems like there was a wreck. I think also if there's concern about that, there could also be, if you feel it appropriate, maybe GPS monitoring to ensure compliance. Also, I'd just ask for some sort of DAS check-ins or something of that nature.
So, Mr. Watson, your proposal is a V-check or a GPS device
Yes,
within 24 hours of release?
yes.
With some reluctance at this time, the court is going to find that an owner cognizance release with conditions is the least restrictive means necessary to ensure the defendant's appearance. The court is going to impose the following. She's to be subject to supervision by DAS or the successor agency. She's not to drive unless validly licensed and insured. And she must carry V-check within 24 hours of release. Our next court date will be December 31st at 9 a.m. for an arraignment. And Ms. Garcia, if you fail to appear at that court date, a warrant will issue for your arrest. Make sure that you're in attendance. Thank you.
Yeah. Yep.
The next case is Colin Castro. And Mr. Castro, you indicated that you will be retaining private counsel.
Yes, Your Honor.
Have you done so at this time?
No, not currently. Once I'm released, I'm planning on doing that immediately.
All right. And Mr. Watson, is the Public Defender's Office willing to stand in for the purposes of today's hearing to assist Mr. Castro with the bail hearing?
Yes, Your Honor.
Thank you. Mr. Reichenberg, what's the state's position?
Yes, sir. In this case, we're asking for $5,000 bail, DAS supervision, a DUI rant to be completed, and testing for alcohol and controlled substances. I understand this defendant scores a 3. However, concerningly, he just had a Reno Municipal Court DUI. He was arrested 5/19 of 24 and convicted in September of 24. And here we have, obviously concerning given the amount of empty shooters under the street, I think, or under the driver's side seat. I think that shows that this defendant is routinely engaging in this type of conduct, and also the fact that there's admittedly, or per the defendant's admissions, Xanax pills and powder. That's a polysubstance issue, and the defendant's only 20 years old. So this is extremely concerning risk to the community. The defendant clearly didn't get it the first time he got a DUI. And here we are back again about a year later with multiple substances here. So this is a concerning case to the state. And we would ask for the testing to include both alcohol and controlled substances. Thank you.
And Mr. Reichenberg, you're requesting random testing or daily testing?
I think it'd be appropriate for daily testing for alcohol and then random for the drugs, as I know that stays in the system for a little bit longer. I think we could leave that to DAS, but I think daily for alcohol.
Thank you for the clarification. Mr. Watson?
Yes, Your Honor. As the state pointed out, Mr. Castro has only one prior conviction, which looks like a DUI from 2024. That is concerning, obviously. We were able to speak with his mom. We were able to verify his address, the fact that he's lived at that address for the last 10 years. He's lived in Reno his whole life. So I think really the only thing that we need to be concerned of is safety community. I think with that, I think an OSM device or something of that nature with the constant testing, and obviously a no driving clause, unless he's got a valid driver's license. He does currently work. He's been employed for the last 3 years. So I just asked for an OR release with OSM device and also DS check-ins, and no driving without a valid driver's license.
What is the OSM? Oh, okay, okay.
It's like a portable.
Yeah. Okay.
Mr. Castro, the court is going to give you one opportunity to demonstrate that you can abide by conditions
Yes, Your
and
Honor.
appear to address these proceedings. So I will release you on your own recognizance at this time. You must submit to supervision by DAS or the successor agency. You're to abstain from alcohol and any non-prescribed substances.
Yes,
As
Your Honor.
you are not legally able to possess alcohol, you're not 21, sir. You will be subject to daily testing or an OSM device for alcohol, random testing for any other substances to be determined by DAS. You must complete a DUI rant. You're not to drive unless validly licensed and insured.
Yes, Your Honor.
Your next court date will be an arraignment on December 31st at 9 a.m. If you fail to appear at that date, a warrant may issue for your arrest.
Thank you, Your Honor. Okay.
The next case is Victoria Carter. This is two causes of action ending in 895 and 896.
Your Honor, we were unable to speak with her today and she has refused to come to court. I would just ask for a 1-day continuance.
Okay, we can pass this until tomorrow.
Thank you.
Let's next turn to Mr. Cervantes.
Present. Oh.
Public defender has already been appointed in this case. He returned a 6 on the risk assessment. What's the position of the state?
Yes, sir. In this case, we're asking for $5,000 bail. The defendant has a pretty substantial criminal history, although it's somewhat remote at this point. His last conviction was in 2010. From 2000 to 2010, he had a pretty steady stream of drug-related issues. His last conviction was for possession of drug paraphernalia. It all appears to be out of Shafter, California. Had under the influence in 8, under the influence in 9, felony conviction for PCS in 2005, drug paraphernalia in 2005, misdemeanor possession of controlled substance and under the influence in 2004. Looks like he had a drug court in that year. Also had a grand theft from a person, which I believe is a misdemeanor, the way it was ultimately resolved. Again, more misdemeanor charges for drugs under the influence, 2000 to 2004. So was fairly concerning, I think, given this seems to be somewhat of a strange incident. Obviously, he said that he was there to retrieve an animal, and it appears that bore out. But the way he did it obviously was concerning. And then the fact that he had methamphetamine on his person, not the largest amount, but again, a pretty decent amount at 7.54 gross grams. And the concern, frankly, here is that he's slipping back into old tendencies. So we believe that 5,000 is appropriate, DAS supervision, and random testing for alcohol and controlled substances, as well as I understand that he had permission from the resident, but the owner, I think, given the fact that the owner was on scene, during this. I think a no contact order with the Gold Coin Motel at that East 4th Street address would also be appropriate. Thank you.
Mr. Watson?
So yes, Your Honor, and speaking with Mr. Cervantes, I think his MPRA is a little bit higher than it should be. We were able to verify, we were able to call his boss that he does work for the local union as a pipe fitter, steam fitter, and HVAC. He's currently working out at the USA Parkway at those big warehouses that they're building. He has worked there for 4 or 5 months. His address isn't verifiable. I think it's because, as he tells me, he's kind of a traveling worker. He kind of goes where the union needs him. So he has been staying in hotels and things of that nature rather than because he might be on a job for, a month or two and then move to another job. It just is kind of, but it seems like it is in Nevada. That's why I also think it said he's only been in Reno for a short time. Mainly because of that, because he did tell me that he was also working out in Eastern Nevada recently. So I think that kind of weighs against him. As far as residence and employment, I think the score should really be more of like a 3 or a 4, based on that information. We were also after speaking with him, it's kind of interesting. His last conviction is 15 years ago. As the state pointed out, there might be things prior to that, but that is very remote. I think this is kind of a one-off, and as the state kind of pointed out, this is a very interesting or odd case, just based on the facts, and trying to get his animal back, which did, as the state said, that did bear out. That was true. Maybe it was not the right way to go about doing that. I think he understands that in talking with him. So my ask today would just be an OR release. I'd ask for an OR release with DAS testing and check-ins as you see fit, Your Honor. And with that, I'll submit.
The court finds at this time the least restrictive means to ensure the appearance of the defendant is an own recognizance release with conditions. The only condition being no contact with the Gold Coin Motel. So, Mr. Cervantes, understand I'm giving you an opportunity to come out of custody. If you fail to appear for your arraignment date, which will be December 31st at 9 a.m., a warrant may issue for your arrest.
Yes, ma'am. I'll be there. Bright-eyed and bushy-tailed. All right. Okay, again. Thank you, sir. I got him.
Thank you.
Thank you, sir. Thank you, man.
Yeah, you can just go back.
Walk through.
Next is Alexar Hatcher.
So, Honor, I was able to speak with Mr. Hatcher. We can proceed, but he did waive his appearance today. He wasn't feeling well.
All right, public defender's been appointed in this case. Is the state prepared to proceed, Mr. Reichenberg?
Your Honor, may we trail that one? I had some computer issues this morning reading that PDF, and I think they're resolved now. I understand it's a child abuse. May we just trail that one briefly if he's not here?
That's fine.
Thank you, Your Honor.
Let's call Jeremy Kane. This is two cases. Yes, it was a jail. And is this Mr. Kane?
Yes, ma'am.
So it's two PCs, 899 and 900. Is the state prepared to proceed, Mr. Reichenberg?
Yes, Your Honor. So with Mr. Kane, so I would note for the court that I do anticipate, I understand these came in as essentially two PCs. I do anticipate filing this all as one. So we're asking for a total of $30,000. If the court wants to put $5,000 on the possession of a controlled substance PC and then 25 on the identity cases, I'd have no objection to that. We'd also ask for no contact with the co-defendants, Ms. Carter and Mr. Tippery. Uh, Also ask for DAS and testing for alcohol and controlled substances. Defendant has scores of 10, had a first conviction for a misdemeanor looting in Douglas in 2001. Had a gross misdemeanor conviction for unlawful taking in 2008 here in the Second Judicial. I think that's noteworthy because he was given drug court in that case, and yet here it appears that he still had, throughout the course of his adult life, issues with controlled substances and alcohol. Had a DUI in 16, sorry, also a petty larceny in 2008. And then a 2020, his last conviction was a 2022 gross misdemeanor taking a vehicle without consent in the second JD. So has crimes indicative of an individual who's has issues with substance abuse, has obviously had treatment for that in the past, and here we are again with crimes that speak to substance abuse and victimizing others in the community to try to pay for that. So we believe he's a risk to the community, risk to continue that conduct, and asks for bail and conditions. Thank you.
Mr. Watson?
Yes, sure. And speaking with Mr. Kane, we were unable to verify any information, mainly because he doesn't have his phone and he didn't remember phone numbers. I would like to point out that he can't afford any bail, so any sort of bail would be a de facto detention. I think the most concerning thing to him is that he does have congestive heart failure. He does have heart problems. When he was initially brought in, he was not medically cleared. He had to be taken to the ER to eventually, I believe, given some medicine to lower his blood pressure. He's had consistent high blood pressure since he's been in custody. So that is a concern, of course, for his safety and just being in jail. Also, in talking with him, it seems like he has a bed at Recovery or Victory Outreach. So my ask today would just be an OR release to an inpatient facility. I think that would, I understand the ad books with all those. We don't know how that's going to bear out. I understand he's got co-defendants. So my ask today would just to be an OR release, but to direct transport to an inpatient facility. It sounds like he already has a bed at Victory Outreach. And then of course with that and just being in that program, there will be testing and supervision, things of that nature. And he knows that he's got to complete that program, that he can't just especially if he's ordered there, he can't just walk away, as that'll just make things much worse for him. That would be my ask today, Your Honor. And with that, I'll submit.
The court finds at this time that the state has met its burden by clearing convincing evidence to establish that the defendant poses a risk of flight, a risk to reoffend, and there is an ongoing concern for the safety of the community. The court takes into consideration the nature of the offense as it pertains to his risk of non-appearance, the likelihood of more criminal activity if he is released, the fact that his risk score is a 10, which is on the higher side. Therefore, bail will be set in this case. I'll do a total bail of $15,000. That's $5,000 on the PCS. $10,000 on the other case. That would be by surety or 10%. He will be subject to supervision by DAS or the successor agency testing. I will authorize direct transport to an appropriate facility by the inmate assistance program. And Judy, his next court date will be?
It'll be a 72-hour on December 19th at 9:30 in the morning.
So you get to, I mean, it's either. I'll take the direct, yeah. That's right. So I don't have a phone number to get a hold of. Well, all I told you, yeah, figure that out when you're your turn, so talk with them. Okay, so I'm just going to get a hold of them now and I can get out direct. Yeah, they gotta transport them. Thank you.
The next case is Jonathan Morrow. Public defender has been appointed in this case. He scored a 3 on the risk assessment. What's the position of the state?
Yes, Your Honor, asking for $2,500 bail, DAS supervision and testing for controlled substances. The defendant has a fairly lengthy criminal history. Appears he's got periods of time where he's sober and doing well. However, his history goes back to 1994. Had a resisting in 94 and then a battery in 95 with no disposition here in the Reno area. Then in 98 had a felony conviction for grand theft in Ada County, Idaho. 99 had a felony conviction for PCS in Idaho. 2005 had a misdemeanor conviction for child abuse or neglect here in Reno. 2007 had a possession of drug paraphernalia in Idaho that looks like it was dismissed. Then he was back in Reno in 15 with a felony conviction for PCS. Had a domestic battery arrest in 17 that was ultimately dismissed, although he also showed a felony failure to appear arrest in that year. I think it was probably on the PCS charge from 15. And then most recently, he had a misdemeanor conviction for DUI drugs and possession of drug paraphernalia in Sierra County, California. So again, lengthy history with controlled substances by his record. And here we have another controlled substances case, and also concerning given that he seems to travel around the West Coast a decent amount, which puts him at risk to not appear. So we believe that the $2,500 bail is extremely reasonable given that criminal history. Thank you.
And when was the Sierra County case?
It was earlier this year. Let me see if I can get a more specific date for you. I just noted that it was in 25. Sorry, I'm just pulling up his criminal history now. That was in July, Your Honor, that he was arrested July 10th, the way it appears, and convicted on July 22nd.
And the NPRA indicates he is still actively on probation for that case.
Yes, he received 36 months probation.
Thank you. Anything further?
Not from the state, Your Honor.
Mr. Watson?
Yes, Your Honor. In speaking with Mr. Morrow, I'd just like to also highlight his MPRA score of 3. I understand the state mentions this criminal history. Some of that though is over 20, 30 years old. I know the state also mentioned there's maybe this concern that he's kind of moving around the West Coast. But in talking with him, he's been a resident of Washoe County for over 20 years. So I think his flight risk is low. He did give us a residence, which I believe was verified, seeing as how his MPRA score is only a 3. He does work at an excavating company. He is supposed to be there today. He also has work, of course, next week. I also think bail would just not be appropriate based on his MPRA score of being so low. I do understand the state's concern with him using, so I would think DAS testing and check-ins would be appropriate. I think that would be appropriate, and then also any other conditions that you would seem to impose, Your Honor.
The court will find at this time that the least restrictive means to ensure the presence of the defendant is an own recognizance release. His next court date will be an arraignment on December 31st at 9 a.m. I'm not going to place any additional conditions,
Thank you, Your Honor.
but certainly if he does have a substance use disorder, the public defender's office can connect him to some resources, but I'm
Yeah.
not going to order conditions.
Thank you, Your Honor.
Thank you very much.
Yep.
The next case is Francisco Ortiz.
So, Your Honor, he refused. I would just ask for a 1-day continuance. We weren't able to speak.
Katie, can we set over Mr. Ortiz until tomorrow? We'll pass this 1 day. The next case is Nicholas Tippery.
Yes, Your Honor. He is another that refused. We did not speak with him, so we would just ask for a 1-day continuance.
Public defender's been appointed in Mr. Tippery's case. Based on the request, we can pass that 1 day as well. Next is Monica Gore. And I understand, Ms. Gore, you've indicated you'll be retaining your own counsel.
Yes, Your Honor.
And have you done so?
No, I have not.
All right. The public defender's office is here and can stand in to assist you for the purposes of today's hearing only, if you wish to go forward today.
Yes, Your Honor.
All right, and Mr. Watson, is the public defender's office willing to stand in for the purposes of today's hearing only?
Yes, Your Honor.
Thank you very much. Order 2 on the risk assessment. Court has reviewed, of course, the documents in this case. What's the position of the state, Mr. Reichenberg?
Yes, Your Honor, we're asking for $5,000 bail, DAS supervision, DUI rant to be completed, and daily alcohol testing, either through OSM or SCRAM device, and no driving unless properly licensed. What is concerning in Ms. Gore's case, one is the property damage that was done here. It appears to be a crash in a pretty substantial object. The mailbox that then caused her vehicle to have quite a crash. And that coupled with, so she just had a DUI conviction in 24. That was in July of 24. And frankly, I guess what maybe the kind of cavalier attitude about the fact that it didn't matter that she was driving because she was in a private community, and kind of her response to law enforcement when discussing this incident. It's clear that based upon all the facts and circumstances here, the prior DUI, that there's a drinking issue that Ms. Gore has not yet come to grips with. And so therefore, we believe that that DUI rant, the daily testing, will be helpful. Obviously, this time of year includes a number of social events where alcohol is potential to be in play. And so we believe that bail and all those conditions are appropriate for the safety of the community. And with that, I'd submit it, Your Honor.
Mr. Watson?
Yes, Your Honor. And speaking with Miss Gore, her MPRA score would most likely be a 1. The employment is that she's an investor / real estate agent. So it seems like maybe that's not, technically what you would consider kind of like full-time employment. But I think her score would be a 1 with just the prior misdemeanor being that prior DUI that the state mentioned. We were able to talk with her mom, verify her address. She's been at that address for over 5 years. She's lived in Reno for over 20 years. She has her own phone number. I think some things could be fashioned. I think an OR release with what the state has recommended would be appropriate, seeing as how this is a second in a short period. I think a DUI rant would be appropriate and an OSM device. And obviously a no driving clause without a valid driver's license. And I think that would ensure safety to the community and her compliance with that. And with that, I'll submit.
Thank you. The court finds at this time that the least restrictive means to ensure the defendant's appearance for these proceedings and to mitigate the risk of safety to the community is an own recognizance release with conditions. So I'm going to release you, ma'am, but with the following conditions that you must abide by. You need to obtain the DUI rant. You shall be supervised by DAS or the successor agency. You're not to drive unless licensed and insured, and you will submit to either daily testing or testing via an OSM or SCRAM device. Our next court date will be an arraignment on December 31st at 9 a.m.
Thank you, Your Honor.
The rant's kind of like an assessment. The OSM device is like a thing you want to. Okay.
You head back to you.
Oh, okay. Oh,
Yep.
thank you.
Next is Philip McInnes.
Medical issues. How would you think of them?
Yeah, so Your Honor, I'd ask for a 1-day continuance. I don't think we talked with him, but he has medical issues, is my understanding. The jail has told me, so I'd just ask for 1 day.
And it looks like he was unavailable to interview for the public defender's office as well.
Yes, I did not speak with him.
All right. Judy, can we pass this case as well until tomorrow?
Yes, Judge.
Next is Cavante Turner. Is the state prepared to hold on, let's see.
Your Honor, we're missing the wins check on this one, so I believe we will need to continue it to obtain the proper criminal history.
So, Your Honor, in speaking with the jail, we were told that his identity was verified. So I'm not quite sure if the state has that information or not. It sounds like maybe not.
I don't. My last note was that it was a wins check, and then I don't have a criminal history for Mr. Turner. I'm not sure if DAS or someone else has been able to procure that yet, but I don't have that information yet. If so, I can quickly review it, but I don't have that in my file at this time.
I'm not sure if the parties heard my clerk is stating the court is not in receipt of any additional information. Let's at least start with screening Mr. Turner for the public defender's office. I don't see that that's been accomplished.
Your Honor, I can just speed that up. In talking with him, he is homeless, doesn't have a job. I believe he would qualify.
Thank you very much. In the interest of justice, the court is going to appoint the public defender's office to represent him in this action. State's asked for a one-day continuance. Defense is indicating his identity has been confirmed. We have one more case to call, so we could trail this for a moment, see if there's any additional information, call the other case and recall this case.
That would be fine, Your Honor, but I also did not receive any sort of criminal background information. So I don't know if that just hasn't been provided to any of the parties yet. If that's something we're just gonna have to wait for.
I don't think I would have the ability to, even if his ID is confirmed, get it on my end, as I wouldn't be able to get my investigator to get that done today, unless the jail has, or there's someone at the jail with alternative sentencing or something like that that would have that could send it to us. I think we need to continue it till tomorrow.
Yeah, and I think that's what the jail is recommending as well.
All right.
History.
Yeah.
You can literally just Google that. You don't even.
We can pass this case one day.
Okay. Okay, thank you, Your Honor.
Thank you. And that leaves Jones. This is the first appearance on a fugitive warrant.
Your Honor, we did speak with him. My understanding is he bailed out on the case that he has here, and he's got a fugitive hold out of California, but we haven't received any paperwork yet. So my assumption was that was just going to be continued to Monday or Tuesday.
For 72 hours.
Or set the 72, yeah, sorry. There we go.
So today's the first appearance on the fugitive warrant. It looks like it's out of San Joaquin County, a no bail holds. And the 72-hour hearing will be
December 19th at 9:39.
So is that the 19th?
Yes, the 19th.
And then, Your Honor, I do again, I'm prepared on Alexar Hatcher. I know he's waived his appearance.
Oh. Yes, thank you.
Right.
So let's recall that case. This is Alexar Hatcher, 898. Public defender's been appointed. Mr. Watson, you previously asked to waive his appearance for today's hearing.
Yes, Your Honor.
This is an ad book. What's the state's position?
Yes, Your Honor. So I anticipate that this will all be filed under his prior case, but we are asking for an additional $5,000 based on the new charge here. We are asking that all the other conditions that were set in his underlying case, including the no contact with the Mount Babcock address, and GPS house arrest was not ordered in that case, although we'd asked for it again here. He had no controlled substances and no weapons. He has a no contact order with the juvenile's mother, Tiffany Wheeler. We would also ask that extend to the juvenile victim CR. If the court needs the full name, I can text that to the clerk if the clerk wants to reach out to me. But we'd also just ask that that be pursuant to NRS 178 as well. That was the no contact on the mother, and I believe the Mount Babcock Street address is where the juvenile resides. So we're asking for, in sum, an additional $5,000 plus no contact pursuant to NRS 178 with the victim, and all the other conditions from the other case to be applied to this case too.
Defense?
Yes, Your Honor. In speaking of Mr. Hatcher, and as the state pointed out, his bail has already been set at 20,000. It sounds like this is going to be one case, as this is an ad book that alleges some other, I guess, crimes. My ask would just to be to leave that at 20,000 with all those conditions. I don't see a need. I mean, I understand his MPRA score is a 6. A moderate. In talking with him, he is currently somewhat disabled. He's set to have surgery within the next couple weeks on his left ankle. He was in a motorcycle accident some time ago within the last couple years that made it that he broke both of his feet, that he's still receiving surgery for. He was working up until that accident, and we were also able to verify he does have an address of 457 Stewart Street, number 1. He's lived at that residence for the last 14 years. He also, prior to his accident, was he refurbished car interiors. He was an apprentice. He was doing that for 5 years up until that accident. It also sounds like the child in this incident doesn't live with him. So I think the no contact order, as the state mentioned, for the 120 days per statute would be appropriate. And so I would just ask for an OR release on this, with seeing as how this is essentially going to be one case, most likely, just an OR release, and to leave that $20,000 that he already has on the first alleged incident. With that, I'll submit.
Court does find at this time that the state has demonstrated by clear and convincing evidence it is necessary to impose conditions and a monetary amount of bail. Based upon the risk of safety to the community, the risk of safety to the named victim in this case. Bail will be set in the amount of $2,000 by surety or 10%. No contact with the minor child, CR, the address located at 13850 Babcock Street. If he posts, he's to submit to supervision by DAS or the successor agency, not to possess a firearm or weapon, as this is an alleged crime of violence. And testing for drugs and alcohol at random. And his next court date will be
The 72-hour for December 19th at 9:30.
Thank you.
Thank you, Your Honor.
Thank you.
See everyone